leeway or provision will have to be carved out. Similarly, like this diversification of the business of the company, again I think it's not so essential to file it with ROC. And how you define diversification of the business? I just pass a resolution that I want to diversify my business and I am seeking some possibility. At that time, this resolution is required to be passed, or when in actual I diversify my business. Again, you see, this requires a lot of thought process. To approve amalgamation, mergers, or reconstructions, to take over a company or acquiring control or substantial stake in another company, any other matter which may be prescribed in future by way of additional rules. Now let's come to the C category. Political contributions. Now the difference, you may ask, what is the difference between the B and the C category? B categories are all those which are given under the Act, and the C, all the arising out of the rules. Basically, political contributions to appoint or remove any EMP. Let's suppose the CFO is being appointed or removed, that resolution is required to be filed. A company secretary is being appointed or removed, that resolution is required to be filed. To take note of the appointment or removal of one level below the KMP. To appoint internal auditors and secretarial auditors. To take note of the disclosures of directors' interest and shareholders. Now, in our secretarial field, there is a lot of talk going on for this item. I don't know, CA fraternity, what is the awareness level for this. This is basically, if you know, in the old Companies Act, we used to give a disclosure known as Form 24AA. That is disclosure of directors' interest. So there is one school of thought which is debating that that entire disclosure is required to be filed with the ROC. Is it so? In my personal opinion, I don't think so. Only you have to pass a resolution whereby you may say that board has taken note of the disclosure which was tabled before the meeting. Or if you want to do more compliance, you may record the entire form and file it along with the resolution. To buy sell investments held by company other than trade investment constituting 5% or more of the paid-up share capital and free reserves. To invite or execute renew public deposits and other related matters thereto. To review or change the terms and conditions of public deposits. To approve the quarterly, half-yearly and annual financial statement or financial results as the case may be. So now you see, in case of a very small private limited company taking some banking requirement, and for that you prepare a quarterly financial statement, that will also be required to be filed out. Because it doesn't restrict itself to only listed companies. So listed companies will prepare accounts on your quarterly basis. Now we are heading towards almost to the last limb of our presentation. And as I told you, I will just be drawing your attention as professionals. We all should be aware about the new criminality aspects given under the Companies Act. Because these provisions are very draconian in nature. Like any other legislation attempt has been made as its own plus and minuses. Certain good takeaways are there and certain leeways are given. For example, you see the CSR provision. What if you don't comply? No penalty is given over there, right? But on the other hand, we have a couple of provisions which are very serious in nature. Please, whenever you get time, please go in detail and read section 439 of the Companies Act 2013. It reads that notwithstanding anything given in the CRPC, every offence under this Act except the offence referred to under section 212 shall be deemed to be non-cognizable within the meaning of the said Act. Bare perusal of section 21 of the Act reveals that notwithstanding the procedural safeguard interest in the CRPC, most of offences have been made cognizable. That is, the person accused of offence can be arrested without a warrant issued by the magistrate. In contrast, section 624 and very just if you don't have much aspect of the criminal law, cognizable and not cognizable, two kinds of offences are there. Cognizable means you get bail in the police station itself. To put it in a very simple term without going into the technicalities, non-cognizable means court will give you the bail. So you see, it goes on to provide that no person accused of some of these offences can be released on bail unless public prosecutor has been given an opportunity to oppose application of such a thing. What if police arrest you and within 48 hours, 24 hours, whenever they have to produce you, anyone, and the PP doesn't turn out that day? Can someone's natural right be taken away? And here we are not talking about some big fraud. Professionals are the most, some certification will be only known. Until and it is of very grievous nature. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds. So second is there is reasonable thing, but the first one you think, I don't think it is reasonable by any chance. That opposite limitations on grant of bail are in addition to the limitations given under any other law. So now you see furnishing incorrect particulars of any information in any of the document filed with the registrar in relation to the registration of a company. Now let's say, as we are aware that now company secretaries and chartered accountants go to do this incorporation work. A client comes to me, I want to register my company. I say, okay, you give me your light bill to show me, or your telephone bill or anything. Each and every document what he has given is classified false. Classified false means it appears to be very true. You are not going to go physically and check. Let's suppose you are having your office at Ford and someone comes from Virar and says, I want to do an incorporation of the company. Are we going to go and check physically over there? Or we will rely on the documents what are given to us. Right? So in that case, just see where we are heading to the first definition. Very small example I am giving. Not giving much complex. Second, quoting false explanation by a person is required to provide an explanation, make statement in an inspection inquiry. This is something else. 250 what we used to have. Just in the first thing, that is of more importance. Knowingly makes a statement which is false in any material particulars, or knowingly makes a statement omitting any material fact in any return report certificate, financial statement, prospectus statement, other document for the purpose of any provisions of the Act and dispute thereof. So, whenever a certificate is to be issued, lot of responsibility is there on professionals to safeguard their own. In that I sum up my presentations, and any questions if required.
Beneficial shares acquired by a partnership firm would be obviously registered in the name of a partner. There also we have to implement.
Partners will have to do.
And if there is a change in the ratio of the partnership,
Then the ownership will also change.
then the beneficial ratio changes.
Yes, perfectly correct. A lot of compliances are there under the new company. I think it would have been better. Compliance Act 2013 we should have come. Compliance Governance Act 2013. Yes. Sorry, public company.
Foreign company.
Voice is not.
Okay. Can you hear me?
I can hear you, but voice is English. Project office after that I was not able to do. Yes, we'll have to do that. Because you are having your place of business over here, you'll have to get yourself registered. Yes, there is a separate form what is required to be filled. Sorry?
lot of details in that return, so it is that required to that company to
No, the information required to be given there is much less compared to this. Quantum of information basically, right? It's much less. But there is one more new concept as a foreign company that even if you are not having anything over here and electronically if you are doing it, then also a lot of compliances are there.
in case of participating notes, if I am investing in the Indian company, beneficial shareholders' names are not known to anybody, and this is permitted by SEBI and FEMA.
What does SEBI permit? What does FEMA permit?
FEMA permits FIs to invest in India.
That also allows you to invest.
But what about the beneficial shareholders' name?
Now the details will come out. Investment is not bad. RBI allows you, SEBI allows you, Companies Act allows you. Only you have to give the name, that's it.
See, some of the, as we understand, the penalty and punishment provision cannot exceed or it will have to be commensurate with the offence committed. Now, some of the punishment or penalty provision, they are far exceeding the offence. So, can we think of going for a constitutional validity check for such kind of?
I don't think it might be a frame. A very simple example I will give. If we eat banana and throw that banana cover just like that, छिलका जो बोलते हैं हिंदी में, what is the offence we are committing? But if a 500 penalty is there, we will say, you know, why 500 penalty should be there, right? So we have to understand from where all these penalties are coming up, the type of scam which has gone, and you go and see the level of compliances what companies are doing. In order to have more discipline, such strict penalties have come. No doubt, but there are some areas like stricter punishment, like criminality aspect that has to be discussed. But monetary penalty, I don't think you comply, no one will levy penalty on you. The whole idea is that the new Companies Act you see is a compliant orient features. Compliance has some value. And the basic law of economics, if anything is coming in free, there is no utility about it, right? If anything, cost is attached to something, we have a utility for it.
But do we have some provision like he was prevented by sufficient cause, or is it mandatory, or say suppose if there is a delay in submitting some resolution? So is it mandatory?
Fine, you can do it.
No. So my question is that is it mandatory, automatic? Are these penalties automatic, or are they if the person was prevented by sufficient cause? Then
again,
is it discretionary?
No, again, but what type of sufficient cause it might be? Because the act, if you see pure legal term, if I want to argue it out or put my views before you, act doesn't give any such thing.
Yeah, so that's my first question. That does act allow that you there's no,
It's automatic.
so it's automatic, mandatory.
In case of a private company, which is after April, borrowing or giving loans, it needs to comply with 186,
Yes.
passing of resolution.
Yes.
That board resolution also is required to be made.
Yes.
By what is the time limit?
30 days.
So which means the borrowings from or the lending from April till today, that 30-day window is expired.
No, I didn't get you. You to be very first April
I
you
want to
passed
grant the loan.
First April you passed
passed
a board
the board
resolution. Right.
Yes.
Right.
So that has to be filed by
30 days.
So
From
by,
the first April.
by first of, because for disclosure there is an extension. There is no rate filing fee for
Right.
the disclosure resolution. Disclosure by directors, I think the last date is 30th of June.
No, but director's disclosure is an internal thing. That is a different
But
thing.
that also needs to be, that resolution needs
But
to
in
be.
the resolution, there is a difference here. I was highlighting that there is
Yeah.
a difference in filing the exact disclosure with ROC and filing of a resolution.
Correct, but filing of a resolution is required with ROC,
Yes,
right?
yes, yes.
For those of us who have not filed that resolution, there is an extension without the rate.
Yes.
Is similar extension available for
No,
us?
no, no.
It's only for that.
Yes. 186 basically you are asking.
Yeah,
No,
yeah.
no special benefits.
For 186.
No.
A private company was permitted to hold a video conference meeting with the foreign director or even within India. What about the AGM?
It is the director of the shareholder.
No, shareholders, let's say both the shareholders are not in India. Then can they have?
Yes, purely as per the provisions given under the Companies Act, you may do so. But again, the challenge will be there on the company and the scrutinizer to ensure that all the facilities are given to the shareholders and whatever most are being casted, they are not being challenged anywhere. The safeguard has to be there.
100% shareholding is a foreign shareholding.
But again, you see that it's again what I am trying to highlight, it's only an option, it's not a mandatory thing. If I give an option and shareholder doesn't vote, then it works well and good.
If there is no issue as voting or
Then
anything,
he will do it.
then there is no issue.
He will do it. You are allowed to do it.
So the permission is there.
Yes.
Earlier it was only for board meeting.
Yes, yes, yes.
Could you throw some light on certain resolutions which under the new act now are required to be filed by private companies? Like
All
186.
resolutions would be 186, 188, 185.
If these resolutions are taken in, suppose, say, extraordinary general meeting, then
And also you are required to do it.
within the
Yes, yes, yes. That is same your Form 23 what you used to do earlier. Only additional thing is the board resolutions now. Earlier you are not in the practice of finding the board resolutions.
Is it 185 resolutions to find any provision making the resolution?
You see, from 185 where I am deriving first and foremost, 185 you cannot do on this, right? But certain exemptions are given to managing director or the full-time director, you can give certain benefits. If you are having a scheme, it is given to all your employees. So obviously you will find a board resolution for that. How without resolution you will do?
form number 23, which the auditor is supposed to upload the appointment. Now, supposing the appointment was made late, but it pertains to the earlier year prior to 31st March 2014 financial year. So that is one question, that how is he supposed to upload that? And secondly,
He was aware of his appointment.
no, but the appointment was handed over later.
No, but how it can be handed over later?
It was lapsed.
It was remain in the file.
No, you have to do the penalty and file it.
No,
The
is it
company has
required?
informed late. The company is supposed to inform within 7 days of the meeting. Company has informed late.
No, but the next question will be, will an auditor accept it?
Yeah.
Actually, I am talking not from a practical aspect, but from a legal point of view. Then the point is, why don't we
Different. What he is asking, that today that facility is not there, what is the solution for that? See that Form 23 has become redundant.
Right.
So for the previous years, I cannot file today. Say for March 13, 14.
For example, that appointment date was, let's say, 15th March, right?
Narendra.
Sorry?
For example, 15th March, the company is appointed you as an auditor, right?
Yeah.
By board resolution, right?
No, no, I don't know.
AGM 15th March, let's suppose, let's go back 2013, let's go back. But again, then we'll go in future. Let's suppose it was done on September 15, 2013, right?
Yeah.
And the company is intimating you on March. That is really basically how.
Yeah. Say, supposing they have intimated on 29th of March
2014.
2014. Is an auditor supposed to upload? If yes, then how is he supposed to? How he
Now
can?
the new equivalent form for auditors will have to do it. And we'll have to, I don't recollect the exact form, but the form is there, the auditor has to upload it. And the best part is, if that is up to the 1st March, you can take the MCSI was not working.
Yeah, it was working. Now it is working,
So
but the
that
form is
answers
not.
your query.
No, no. This was pointed out. They are going to resolve it. They are going to resolve it. This was pointed out.
No, as on date I am talking, I don't know about the future, what ministry will do.
No, they have to do it immediately. They have to do it immediately.
I agree with you, sir, they should do it immediately, but I can't comment on that or give my view. So something, what is in future, God knows what they will do it.
One of the gray area which is required.
One of the great, right. ministry will come out very soon, but till that time we have to live with it.
No, he is giving some solution.
I know that the form I was telling that there is a specific form. I am not able to calculate it.
With raising ticket, na? With raising ticket.
Now, thinking of there is no gray area in regards to penalties. They are very clear cut. So, sir, is it not possible or it is not fair that for some time they also take all this penalty procedure and present on board with the all stakeholders of the company that are well aware of the provisions. Otherwise, all these penalties they will have to use for constructing the prisons to imprison the people.
But sir, my humble reply to that will be we as a professional should have been written up long back. Because the Companies Act you see is not a piece of legislation which has come in a jiffy like that. It was for ages it was being discussed. And this time when it was coming, you were not aware. It was something like हिंदी में कागज में शेर आया तो वैसा हुआ था, something like that. It is not going to come only. You are under that impression. Many of us, literally. And again when the rules were coming, how it can come so fast? Because the SEBI had come out with a circular from 1st October, certain provisions will be there. There were various schools of thoughts which were going. So penalty, I don't think it will go only in future, it may become more hard. So you just see for the listed companies now, related party transactions are much more harsh compared to whatever is given under your section 188.
But they will have to administer this in a rarest of rare cases or probably in
God knows. So you never know what stand legislation when they will take what. Now tell me under which provision of law Mr. Subhadrava is in. Which section?
Sir, which section?
Which section he has committed a crime to be in the jail?
But he has actually made a public issue.
No, but which section that is yet to be decided? Which section? If someone jails me for 6 months, under which section?
He has been kept for contempt of court.
Right now, no, even for contempt of court, the court has very clearly said we
Like
will
they
decide
will be
afterwards.
deciding.
That's why I'm telling you now, it's something like you do this, otherwise I will not release. And there is, unfortunately for that poor guy, there is no court above Supreme Court he can go for an appeal.
But
On a very serious note.
he deserves.
That is
No,
ethically
sir, he deserves or not, that is a different thing.
See, my simple submission is he has violated all the provisions of SEBI law for public issue. He has not made a prospectus and he has made a public issue.
But again, sir, that is a very subjective thing. Let's take a classic example of a Vodafone case. Up to Supreme Court, Vodafone was wrong. They won in the Supreme Court. They become right in the income tax.
No.
Guys
Sir,
are wrong.
Vodafone is still wrong.
No, 1 minute, sir, 1 minute. Then Finance Minister came out with his own googly with a retrospective amendment.
You are making a very light remark about a serious issue. Vodafone is wrong and Supreme Court, with due respect, is wrong.
Sir, again, but how we can assume for one case Supreme Court is wrong and in one case Supreme Court is
Let
right?
us not debate on income tax, let us consider companies like.
So in a private company, there are many case issued to an HUF. Whereby you cut off HUF. Whether this will be.
But Karta is this rule legal or not?
Yeah.
So I don't know beneficial holding.
Karta is holding on behalf of HUF.
But for all legal rights are lies with the Karta.
The 1956 Act, I think there was a circular that 187C declaration is not.
That is the logic behind it. So if his name, they all the contract rights.